Good afternoon. Welcome to our December 2021 Reach 3030. As you know, we have Reach series every other month. So we just had our Tosco on. I hope a lot of the people who are listening to that are on this program. This one I think is particularly interesting for U.S. companies. We're going to update you on where things stand on the initiative to require registration of polymers under Reach. As you know, polymers are exempt from Reach currently. You register the monomers that are contained in the polymers instead, but there is a serious move afoot to require registration of a large number of polymers, tens of thousands. And we're also going to talk about a high-level roundtable that's been organized to discuss various implementation issues that's now focusing on getting tough on enforcement of violations of Reach by companies. Next slide, please. I'm Herbert Stryker. I give all of these. Next slide, please. I'm joined today by my colleague, Alesh Bartel, who is a Czech lawyer in our Brussels office, and he co-presents on all of these as well. On occasion, you may notice he presents by himself, but he always does an excellent job. Next slide. So I wanted to update you on polymers requiring registration. Next slide. You may recall, if you're paying attention, that I last presented this topic in July. And I think this is a very, very important topic because, if I was a U.S. company involved in producing polymers and exporting them to Europe, I would pay a lot of attention to what's going on here because this could be a very, very expensive exercise as it plays out. So I'm just going to recap in a few slides what I said in July and then give you an update as to what's been going on since then. You may recall that the Commission has established a subgroup of experts from the EU member states. It's called the CASG Polymers Group, and they're working to develop a proposal for the registration of, quote, polymers requiring registration, PRRs under Reach. The main activity today of the subgroup, the group has been to work on the EU definition of polymers of low concern. And we'll go into that in some detail. But basically, they're going to divide the universe of polymers into polymers of low concern. And then most other polymers will be polymers requiring registration. So there'll be a lot of polymers that require registration. Now, unlike most countries, this will cover not only new polymers, but also existing polymers. So as you know, in the US, you have to register polymers unless they're qualified for the TSCA polymer exemption, but that only applies to new polymers that are not on the TSCA inventory. The Reach proposal or legislation that will be developed will cover not only new polymers, but also polymers that have been in Europe on the market for many, many years. Next slide, please. You can't see this, but we are putting our slides on the website. It's Reach 30/30. It's easy to find. We have our presentations and our slides, presented shortly after the meetings. But if you actually sort of go through this, you'll see that if something is considered a polymer of low concern, you'll have to notify that information about that polymer to the European Chemical Agency. If it's not a polymer of no concern, then you have to decide whether it is a polymer requiring registration. And in general, if it's an intermediate, it would not require registration, but it would simply require notification. But if it's cationic polymer, if it's a polymer of low molecular weight, if it's a polymer that falls into any particular hazard classes, and there are 12 of them, if it's a polymer that has functional groups of concern, if it's a polymer that's surface active, or if it's a polymer that degrades into substance of concern, it will require registration. So most of the polymers that are not polymers of low concern will require registration under this new scheme. Next slide, please. So just to recap, where things stood in July. It was recognized that there are a large number of polymers that will require registration, probably tens of thousands. And so a strategy is needed on how to group polymers to limit the number of registrations that will be required. And the group and the Academic Commission have been working on that, and I will report on where they think stand. In July, prior to July, the European Chemical Agency proposed to group polymers based on the identity of starting materials and to apply what's called, we well know is called the 2% rule. So if you have, three monomers in your polymer, and one is present at less than 2%, then basically that would be identical to a polymer with only those two monomers. And then under the 2% rule, they would allow the use of different reactants that contribute to less than 2%. The polymerized portion would be allowed under the same registration. The ratio of the reactants could vary. So if you have a polymer A, B, C, they could have different ratios of those monomers. The impurity profile could vary. The molecular weight could vary, and the order of the monomers and the tacticity could vary. So 2% rule would help a great deal in terms of limiting the number of registrations that are needed, and these other kind of variations that would be permitted would also do quite a bit to limit the universe of polymers that would need to be registered, at least to some extent. Now, in July, or part of July, a number of the member states wanted notification not only of polymers that require registration, but also polymers of low concern that were exempt from registration. And the debate now is how much information should be included in that notification. There are basically two options: one to have minimal information, and the other is to have a significant amount of information. And we'll go into detail about that. It looks like the champions of requiring a significant amount of information for notification are actually winning that debate. Next slide, please. So what's been happening recently? Well, the most important thing is that this CASG polymers group, which was supposed to disband at the end of this year, contemplating that they would be finished with their work, has actually, their mandate has now been extended until the end of next year. Well, that's important because that means that whatever legislative proposals developed will be delayed. It was originally the Commission's contemplation that they would have a proposal in 2022. It now appears that the legislative proposal will not issue until a year later, or even then. But in any event, the work of the CSG Polymers Group is not finished. There's still a large number of open issues, and that has caused the Commission to extend the mandate of that group. Now, although there are a lot of open issues, there are some things that appear to have been decided. There'll be a notification process, I already mentioned. It'll be similar to pre-registration, which we had in the old days leading up to the registration of substances. But in fact, more information will be required in this notification process than was required in pre-registration. So it'll be a very time-consuming and involved notification process that'll lead up to all this. And both polymers requiring registration and polymers exempt from registration will need to be notified to the European Chemical Agency. So there won't be any self-executing polymer exemption like we have under TSCA. You'll have to actually notify, which you have to do in countries like Korea, in Japan, elsewhere around the world, where you notify your polymers low concern to the authorities to demonstrate that they actually qualify as polymers low concern. It's also been agreed that there'll have to be some mechanism for identifying polymers that provides greater detail than simply CAS numbers. You know, as in the US on the TSCA inventory, polymers are listed by the CAS name, the CAS number, which is usually simply a listing of the monomers and reactants that are used to make the polymer. But it's recognized that for the purposes of REACH, in particular to facilitate data sharing, there'll have to be far more information. Certain polymers will be exempt because they meet the definition of polymers low concern. However, there'll be fewer categories of polymers that qualify as polymers low concern than what we're used to in the US and elsewhere. Next slide, please. So, for example, it's already been decided that fluorinated polymers will not qualify, will never qualify as polymers low concern. That's only certain fluorinated polymers are carved out of the TSCA exemption, but for REACH purposes, no fluorinated polymer will ever qualify as polymer of low concern. Water absorbing polymers will also never qualify as polymers of low concern. And then there also has been decided that there'll only be one oligomer content limitation, and that'll be 2% oligomer content at molecular weight of less than 50 Daltons, and 5% oligomer content for less than 1,000 Daltons, less than 10,000 Daltons, sorry. I mean, molecular weight of less than 1,000 Daltons. And so that's different than TSCA rule. Everywhere else in the world, there are really 2 tiers of oligomer content limitations. And a 2% rule, although will apply generally, will not apply if the minor monomer reactant is a chemical concern. That's a problem. And grouping of polymers will be encouraged. However, it does appear from discussions that the opportunities to group polymers into a single registration will be limited. However, polymers with varying molecular weight will be registered as single polymer. So if it is, let's say, molecularly less than 1,000, 1,000 to 10,000, or 10,000 plus, that'd be a single registration. However, you'll have to develop data on the worst case, which is presumably the polymer with the lowest molecular weights. And as always, on the REACH, data requirements will depend on tonnage, with more data required at the higher tonnage band. Next slide, please. There was a lot of effort by industry to embrace the idea that one would register polymers based on their uses and exposure. So, so for example, all adhesives would be a single registration, and that's been roundly rejected by the authorities. The grouping of polymers would be based on chemical composition. Also, industry urged that grouping be based on hazardous properties. So, for example, all sensed polymers that were irritants would be registered together, and that has been roundly rejected by the authorities. So basically, industry has made very little inroads in this entire discussion. One problem has been that there really hasn't been a lot of data presented by industry on polymers in terms of the hazards of polymers, and so they've been operating in a vacuum. Quite frankly, it's somewhat surprising, given all the polymers that have been registered in Canada, China, Japan, and the fact that polymers are actually part of Korea REACH, and the companies must be collecting data for the 1,000 plus tier on the Korea REACH, but very little of that's been provided to the European authorities. And so industry has been sort of arguing for these sort of broad grouping propositions, really in a vacuum. It hasn't made any inroads. There is agreement that high molecular weight polymers are in general less hazardous than lower molecular weight polymers, and should have a reduced data requirements. However, there is a call for doing screening level tests to confirm that higher molecular weight polymers are in fact low hazard. There's also recognition that the degradation of polymers is of concern, and that even higher molecular weight polymers may not qualify as less hazardous substances because if they degrade into substances of concern. Next slide, please. I mentioned notification of polymers. That'll be notification of things that are exempt from registration as well as polymers that are subject to registration. So all polymers will be notified. There are 2 options being considered. One is to have minimal information, which would be substance identity and tonnage band. The other one is to have much more detailed information. So it'd be substance identity, tonnage band, chemical composition, polymer, pretty extensive chemical composition, the content of the functional groups, structure of the polymer, basic physical chemical data, and the processing conditions. And it appears from the discussion that this more extensive option is being favored by the authorities. Next slide, please. Okay, now I'm going to turn this over to my colleague, Alesh.
Thank you, Herb. So I will briefly introduce the recommendation of the high-level roundtable of the chemical strategy for sustainability on enforcement. So just as a background, as you probably know, chemical strategy for sustainability has been announced last year as a strategy of the European Commission to achieve a toxic-free environment by 2030. And this strategy will materialize in extensive amendment of REACH, and first proposals are expected by the end of 2022, but probably it will be later. It will be in 2023. Next slide, please. So what is the roundtable for the strategy? So it was set up by the Commission, and it includes 32 representatives, including industry association, CEFIC, SME United, Cosmetics Europe, Eurometo, and ICE, which is an association of detergents, detergent products. And it also includes major industry players: Henkel, Covestro, Solvay, Corbion, which is a food ingredient company, and Coop Denmark as a retailer. And the goal of the roundtable is to meet a few times per year in order to advise the Commission on implementation of the strategy, and also to act as ambassadors of the strategy. That means to promote the goals of the strategy. Next slide, please. So the first meeting of the roundtable after the first meeting earlier this year was held in November 25 and focused on enforcement to implement the zero tolerance approach to non-compliance, which is one of the goals of the strategy. And of course, efficient enforcement of the strategy is not only in the interest of authorities, but also in the interest of industry, because it's only efficient enforcement will ensure level playing field in the new initiatives in the future. So as a background, the Commission has already announced independently of the roundtable several measures that are envisaged. First one is strict enforcement of no data, no market. That means revocation of registration numbers in case registrants do not comply with compliance checks or substance evaluation decisions. The Commission also wants to expand the role of ECHA's enforcement forum to coordinate enforcement authorities, including IT enforcement platforms and customs authorities. And the Commission is also envisaging funding and human resources assistant for national authorities through ECHA enforcement forum, because ECHA or EU enforcement initiatives lack funding. Basically, they are becoming less efficient and less widespread. Next slide, please. So now for the recommendations of the roundtable. So the first recommendation is that there should be a whistleblowing mechanism for businesses and their employees to flag illegal products from competitors or their own companies. So there should be some kind of platform with ECHA and with the national authorities where individuals could directly notify, flag non-compliance of their competitors or of their employers. This has been strongly supported by industry representatives in the roundtable, because this will really ensure, or this may really ensure, the level playing field within the industry. But of course, the SMEs are a bit concerned that the system could be open to abuse, with large industry policing smaller rivals. And that it may undermine trust, for example, within industry associations. In general, SMEs are concerned that the chemical strategy for sustainability will mainly affect SMEs rather than big companies that have sufficient resources, not only to comply, but also, for example, to develop alternative substances. So to address these concerns, there is a recommendation that there should be a clear process that allows companies to defend themselves and filters out vexatious complaints. So that's for the whistleblowing. Next slide, please. Another recommendation is that consumer organizations should be empowered to become market watchdogs for chemicals. Again, there should be direct reporting to EU and national authorities of suspected infringements. And there should be support to develop their capacities for collective redress actions, class actions. related to breaches of EU chemicals legislation. In this respect, it is interesting to note that there is a recent directive on class actions, and the goal of this directive is to make class actions in the EU easier, and it wants to achieve by two means. First, mainly by two means. First, every member state will nominate qualified entities that will represent consumers in class actions and that will receive financial incentives to start class actions. And second mean to promote class actions is to make cross-border class actions easier. So currently, this directive only applies to legislation in sectorial EU legislation, basically related to product regulatory, but also to CLP. So class actions under CLP can already be filed under the new class action directive. REACH is not included in this directive, but it may be that it will be included in the future, or that the strategy will implement similar provisions for REACH in the REACH itself. Next slide, please. Another recommendation is to focus on online sales, because online sales are in general considered as being subject to non-compliance. So the focus should be on direct purchase by consumers and end users via online platforms outside the EU. So maybe not necessarily direct purchases from companies outside of the EU, but through online platforms. And the goal should be that online platforms must be held liable under certain circumstances and have clear obligations to be more transparent on trader and mainly product information. And the roundtable mentioned the draft Digital Service Act that will require platforms to verify information from traders, so only legitimate traders reach consumers. So the Digital Services Act, as it is now, is not covering REACH, but this may change, and this is one of the recommendations of the roundtable. Next slide, please. Another recommendation is to increase testing capacities in the EU, with the goal to prepare for enforcement of new restrictions. As we already mentioned several times in our presentations, one of the goals of the strategy is to phase out substances of concern by grouping for restrictions, or by extension of generic approach to risk assessment. That means by focusing more on hazard of substances rather than on risk. And all this is expected to lead to new restrictions for substances for non-essential uses. So in order to enforce all this, the Commission should develop harmonized and standardized control test methods so that enforcement authorities know what tests, what methodology to use for enforcement, substance related, so that they know which substance should be tested by which methodology. And furthermore, the Commission should also ensure by funding or infrastructure development that there is sufficient laboratory capacity, including non-EU capacities, and also that there is sufficient resources in laboratories in the EU and potentially also outside of the EU. Next slide, please. Other recommendations is that there should be harmonized level of sanctions across all member states. So there should be the level of fines, or the amount of fines should be harmonized, so that the current situation where the fines really, there is a lot of variety in fines, really from very low fines to basically unlimited, so that this situation ceases, and that also the human resources are proportionate to the size of the chemicals market, because there are some member states that simply lack staff in enforcement. Another another initiative would be inspection and compliance check fees that would be imposed on non-compliant substances, dossiers or product. So currently, if you have a compliance check, you basically don't have any related fees. You don't pay to ECHA, you don't pay to authorities. So this should stop. In case that your substance is found non-compliant, there should be fees related to inspection and compliance checks. It's also recommended that there should be name and blame lists, so publicize non-compliant companies as one of the initiatives to discourage companies from non-complying. And overall, the goal of all this should be that the cost of compliance must not be more than the cost of non-compliance. This is the last slide. Herb, do you want to add some final thoughts?
Yeah, I had a couple of questions for you. So you had a one slide that they're going to revoke registration numbers in the event of, I guess, incompliance of the dossiers.
Mhm.
I thought the Commission's legal services had concluded at one time that the ECHA did not have the authority under the current version of REACH to revoke registration numbers.
Yes, this was included in our presentation in our first presentation on the strategy 1 year ago.
Yeah.
But since then, it has been repeated several times in any communication on the strategy by the Commission that this is going to happen. So I think overall there was quite a big pushback at the beginning of the strategy by DG Grow,
Yeah.
and maybe DG Legal Service. But I think in the meantime, the Commission directorates and services aligned.
So, whether they have authority or not, I guess, remains to be seen. That seems to me that could lead to a legal challenge.
Well,
So,
it may also be the REACH may be amended.
Yeah, well, that I understand. Let me ask you another question. This sort of business about the class action, the CLP.
Mhm.
So, what do the members of the class actions get? Do they get money? What's their incentive of bringing a class action?
Well, yes, they will get money, and they may claim damages. But of course, it's normally what you can claim is rather low, because you basically mainly claim the actual damage. So that's why.
What would I don't understand the damage? Well, obviously, if you're harmed, you could have product liability case, which is different than having a class action because there was something missing from a safety data sheet or label.
Right. So it's mainly in case of a harm. So if there must be a harm. Yes.
I see. So the EU is finally joining the US in terms of class actions left and right.
Yes.
I mean,
yes.
are you surprised that industry seems to be embracing this whistleblowing stuff and all that kind of stuff? I mean, that seems to be.
Well, at least companies in the roundtable do, and I think it's indeed this big industry will be compliant. So I think they have interest that their competitors that do not comply are caught.
Let's hope they're all 100% compliant. Okay, next slide, please. So I just want to remind you that we have our REACH 3030s every other month. So we're not going to have one in January. The next one will be February 9th. We have our next task 3030 on January 12th. Our OSHA 3030 is December 15th. And tomorrow we're having for people who are interested, a webinar on the American Disabilities Act in terms of website accessibility lawsuits. So apparently, the idea is that websites should be designed, company websites should be designed in such a way that people with disabilities can access the information. So that's tomorrow. Next slide. I'm Herbert Stryker, and joined today by my colleague Alesh Patel. And I want to thank you all for participating, and have a great holiday season. Take care, everybody. Bye-bye.
Bye-bye.